Hello everyone, this is Jaya, 5th semester School of Law student at Christ Deemed to be University, Lavasa campus. And today I'll be sharing with you the details of the case of Ramanna Dayaram Shetty versus International Airport Authority of India, popularly known as the case of R.D. Shetty. This case was decided on 4th of May 1979 by Justice P.N. Bhagwati in a three-judge bench. Um, this case forms to be a landmark judgment in the areas of administrative law and constitutional law, where it expands and decides the ambit and scope of Article 14 and Article 12. This case also reflects on the principles of democracy and tells us how accessible the judiciary is for each and every person who feels cheated or feels that his rights have been denied to him. So, a similar situation happened somewhere in January 1977 when the International Airport Authority of India, which is a corporate body constituted under International Airport Authorities Act of 1971, issued a public notice for inviting tenders for putting up and running a second class restaurant and two snack bars on the premises of International Airport at Bombay. A total of 6 tenders were invited. Now, before discussing the tenders, it is also important to note that there were two important clauses of the notice. Now, paragraph number 1 of the notice said that the eligibility criteria is set for only registered second-class hoteliers with an experience of 5 years. And paragraph 8 states that all the powers of accepting and denying the tenders received relies with the airport director. And he has every authority to reject any or all of the tenders without giving a reasonable justification to any of them. So, when these tenders were received on January 25, 1977, there were 6 tenders, and out of 6, only one tender of respondent number 4, Mr. Kumaria, was accepted because of the full compliance to the documents required. Now, after acceptance and rejection of the tenders by the airport director, there was certain correspondence between respondent number 1, that is International Airport Authority of India, and respondent number 4, which is Mr. Kumaria. And the respondent number 1 was very keen to seek some documentation and proof in regard to whether respondent number 4 is the registered second class hotelier or not. Well, it is also important to note here that there was one Mr. A.S. Irani who was already running the restaurants and snack bars in the premises of International Airport at Bombay, and his tender was rejected on 25th of January. In regard to the tender of respondent 4, the acceptance was given in April, and within 6 months, the respondent spent around 1,25,000 rupees to make arrangements for the setting up of restaurant and snack bars at the International Airport Authority. Now, when we move on, we notice that after 6 months of this date, Ramanna Dayaram Shetty moved a petition to the High Court stating that this act of the government, which is the International Airport Authority of India acting in the capacity of state, is arbitrary and denies him the equality of opportunity to conduct business. When this question was reached the Supreme Court under Article 136 of the Constitution by way of special leave petition. The question was raised by the court whether the petitioner has any personal interests, or how does he have any rights being arisen out of this case. Because Ramanna Dayaram Shetty was never one of those people who filed the tender. He did not fulfill the eligibilities of the case of the tender, and hence he did not file a tender. And how is he questioning the eligibility of the tender of the contract between respondent 1 and 4? Because he doesn't have a locus standi in legal terms, or in general term, he doesn't have any personal interest arising out of it. So this case, if I mention, is a very beautifully argued case and a very minutely decided case, while keeping in mind the facts and questions of law. The very purpose of allowing this petition was the nuances of this case that brought in and questioned the law in a different way. So moving forward, when we discuss this case, we realized that there were two issues raised by the petitioner, and they said that what is the meaning of the expression registered second class hoteliers, and if the respondent number 4 was eligible enough to file a tender. The second question that came in front of the court was whether the state, in capacity of International Authority of India, was reasonable enough to accept the tender by way of a public notice. Now, when we discuss about the state, it is important to look into the definition of state under Article 12 of the Constitution of India. And when we break down the definition, we come across 4 broader categories which form a state, or which act out in the capacity of a state, which is Government and Parliament of India, which means central government and central legislature, government and legislatures of all states, which is state legislature and state governments, all local authorities, which is municipal corporations, gram panchayats, or any such local bodies, and other authorities which act under the control of Government of India or within the territory of India. So, which includes any authorities, statutory, non-statutory, which comply with the 5-pointer test of Ajay Hasia versus Khalid Mujib, and also any authorities like foreign embassies, Indian embassies to foreign nations, which are under the control of Indian government. And when we look at the definition, we realize that International Airport Authority of India quite fulfill the conditions of acting as a state or being considered as a state, which means there is a right of claiming fundamental rights by an individual against the authority. Now, how do we claim, and what all fundamental rights have been infringed in this case? So when Ramanna Dayaram was arguing his case in the court of law, he pointed out that registered second class hoteliers means that there is an exclusion of certain category of people. And when we look at the case of respondent 4, he was never a hotelier. So while pondering upon the meaning of what a registered second class hotelier is, the court comes to a conclusion that it is difficult to grade a person as a hotelier, and hence this expression would mean and include people who run a second grade hotel or a restaurant, which is duly graded by the Bombay Municipal Corporation. Also, it required a 5 years experience of running the second class restaurant or a hotel. However, respondent number 4 was carrying out the business of providing catering services to various institutions like banks, factories, training centers, etc. And he was never a person who runs a hotel. Even if we look at his history of work from 1962, he's only worked as a hotelier in Delhi for a period of 4 years and 2 months, which again does not qualify him to file the tender. However, he filled the tender and it was also accepted by the authority, and there were also arrangements made accordingly. Now, Ramana Dayaram Shetty argues that this act of the state of the International Airport Authority was invalid and arbitrary in nature, that he is denied of the equality of opportunity to conduct business. If he would have noted, or if he would have been informed that the eligibility criteria would not be taken into consideration that strictly, he would also have filed a tender and competed for the same. To which the respondents argued that the eligibility was never really important, because it is just a mention and all the powers were in the hands of airport director to reject or accept the tenders. But the court found it otherwise. The court said that there was the correspondence between respondent 1 and 4 during January to April shows otherwise, and hence it is very much clear that they wish to exclude people who do not run a second class or a second grade hotel or a restaurant. This act of the state was considered to be arbitrary enough by the bench, and hence the case was announced in the favor of R.D. Shetty. However, this case is also unique in the feature that even though he was allowed to argue on certain questions of law, but he was never provided the relief, because he did not had any personal interest arising out of the contract between respondent 1 and 4. So that is all about the case. There were certain cases like Menaka Gandhi versus Union of India, Sabajit Tiwari versus Union of India being discussed and referred, and that's how this case turns out to be a landmark judgment in itself. So thank you for listening and visiting this, and goodbye.